Analyzing Case Studies by Kimberly Bird. Defamation and libel are words that have essential meaning to attorneys, lawmakers, and journalists. Many people often believe they are protected against these civil actions under the court of law due to the First and 14th Amendments. However, what is often misunderstood is that in order to conclude that either of these has occurred, the plaintiff would also need to prove intentional maliciousness as in accordance with the law of the state. For example, in the state of North Carolina, which is where I currently live, libel per se is represented under 4 categories. Charges that a person has committed an infamous crime, charges a person with having an infectious disease, tends to impeach a person in that person's trade or profession, or otherwise tends to subject one to ridicule, contempt, or disgrace. Each of these is representative of what is needed to prove that defamation of the person has occurred, and a civil action for sufficient damages will be considered. According to Legally Speaking, an article produced by the Communications of the Association of Computing Machinery, defamation merely means a damaging statement in printed or written form, including signs, publications, and motion pictures, and slander, damaging the statement that is spoken. With this said, defamation is not easily proven, nor is it always the case. As I will examine in the case studies of the New York Times versus Sullivan, Gertz versus Welch, defamation manifests itself within malice and reckless regard for the truth, as both parties must prove how their character or profession was tarnished due to specific actions that were taken against them. These are their stories. The New York Times Company versus Sullivan. In the cases of the New York Times versus Sullivan, a public official alleging untruthful statements have been written about him, printed an article filed about him in a printed article filed a lawsuit against the newspaper publisher. He also contended that these statements contained false information that were done with purpose to damage his character professionally and personally within the state of Alabama as a law enforcement commissioner as well as the leader of public affairs. The statements comprised of information about the police actions that were allegedly directed against students who were participating in a nonviolent civil rights demonstration, which included a leader of the movement and clergymen as well. According to the plaintiff, he determined that the statements were a direct attack on him, as he was the leader of the police department who would have authorized such use of tactics against the school students. Within this case, Sullivan had to prove that the New York Times maliciously published an article against him, knowing that the facts displayed were untruthful and damaging to the professional character of the plaintiff. Why did Sullivan feel his reputation was damaged by the New York Times publication? L.B. Sullivan is one of 3 commissioners in the city of Montgomery, Alabama, of which his jurisdiction includes the supervision of the police department and the fire department, and the Department of Cemeteries, and the Department of Scales. He served as commissioner of the public affairs for each department, and determined that his position was targeted as an authorizer of such violence against the peaceful civil rights movement. Not only did he file a civil suit against the New York Times Company, but he also included students, clergymen, and civil rights leaders in the action as well, claiming that they supplied falsified information to the newspaper company. The article written and published for the New York Times called Heed Their Rising Voices discussed how African American students were currently participating in peaceful protests for civil rights in the state of Alabama, where segregation was still a widespread policy heavily supported by lawmakers and their constituents. The article alleged that students were threatened with terrorizing tactics by a police force of whom Sullivan was supervising. In efforts of fighting for their rights against the U.S. Constitution and the Bill of Rights, the students were refused privileges of which the Times charged the department with wrongdoing. The events that occurred that day were described as a wave of terror while the country watched on television as these people were brutally denied their fundamental rights as citizens of the United States by the Montgomery Police Department. Sullivan concluded that his reputation was damaged by these allegations, and he did not authorize tear gas attacks, padlocking of university dining halls, or further efforts to starve the students into succumbing to the demands of the police department. The article also accused the police department of bombing the home of Dr. Martin Luther King, of which most nearly killed his wife and child, arresting him 7 times, assaulting him physically on numerous occasions, and charging him with perjury in the local court system. When the article used such words as they, Sullivan determined that the journalists were referring to him since the police department were the alleged culprits and he was the supervisor. What must the plaintiff show to prove defamation? According to Legally Speaking, proving libel involves demonstrating how unlawful printed statement was damaging to the reputation of the plaintiff. Within this case, according to the U.S. Supreme Court, the plaintiff must also prove that the defendant knew the information was false before distribution and maliciously trying to harm the alleged injured parties. Alabama law also states the punitive damages in the libel suit were derived from a publication against a public official will be denied unless he first makes a demand for public retraction and defendant fails to comply. The U.S. Supreme Court emphasizes that unlike Christensen, whose statements were paid commercial advertisements, these statements made by the New York Times were opinionated, recited grievances, protests, contesting abuses, while seeking financial support from supporters who regarded their concerns with high priority. In addition to the types of statements that were made for libel to be proven, the plaintiff must also prove that the statements injured their reputation in the public, which caused contempt to his image. The jury must determine that the statements were written by the publisher against the plaintiff and that the words caused injury or harm to his image as a government official. If the defendant has been found to cause injury, they must persuade the jury to believe that the statements are true. If the plaintiff is a government official, his position automatically allows his image to be taken into consideration. If the defendant is not able to shift the burden of proof towards the plaintiff, pecuniary damages may occur and be rewarded without proof of wrongdoing. Furthermore, the law states that good motives rely solely upon truth and do not manipulate it by inferring malice, but applicable punitive damages as the jury should allow. Libel must be determined by the standards referenced by the First Amendment. What was the Supreme Court's decision and how did they make it? The jury determined that the plaintiff had not proved malice, and overall the verdict in favor of the defendant due to the fact that he had only merely proven how his public image was tarnished, but did not provide substantial evidence that malice was used intentionally or unintentionally. Likewise, due to the probability of the damage to the public image being so great, injury to reputation with some time and within some time of their tenure is likely to occur. The judge also reversed the judgment of which the jury did not determine the differentiation of general and punitive damages, and the verdict was an award in its entirety of the other. The case was also reprimanded. However, with respect to liability of the Times and their negligence of verifying whether or not all of the names, information, and references were true in accordance to the law, they are found liable. The Times wrote an article of which they did not verify any and all sources and instead took most of the information from a person whom they found most respectable. In return, they used the information against the will of the plaintiff and other parties involved in the published article. The court determined that the Times failed to verify all information before publishing by not clarifying the information with those mentioned in the article, but does not show means of violating the Constitution by using malice against the sources mentioned. Lastly, the court also determined that because the plaintiff was never directly mentioned in the article by the respondent, using name or official position, the Times would not be held liable. The events mentioned to have taken place at the university and the allegations and damages made against Dr. King were never directly published as direct correlation with the name of the plaintiff nor the police department. Gertz versus Welsh. Who are the parties in this case? Is the petitioner a private person or a public figure? In the case, Gertz versus Welsh, the family of the victim who was murdered by a Chicago police officer retained an attorney for civil litigation against the accuser, and the article was later published by Welsh for an American Opinion magazine, stating that the trial of the officer was a communist conspiracy to discredit the police department, also alleging that Gertz had a criminal record and further labeling him a communist. In this case, the petitioner is a private person as he is the lawyer who represented the family of the murdered victim. What were the alleged defamatory statements about Gertz in the American Opinion article? In the monthly periodical called American Opinion, that consistently featured content warning against a nationwide conspiracy to discredit law enforcement agencies and instead create a national police force aimed at supporting a communist dictator. The managing editor of the magazine alleged that the public was in danger due to prosecution of Nucio trial being corrupted by the communist dictators. The article also alleged that the testimony of the defendant was not true due to the distorted nature of the prosecution. In addition, the article stated that the police file against Gertz was plentiful and had been an active participant in the Marxist League for Industrial Democracy, also known as the Intercollegiate Socialist Society, who were known to be violent against the government. Gertz was further named a Leninist and a communist frontier. Gertz was also listed as being an officer participating in the National Lawyers Guild, which was also described as a direct association with communism and was most responsible for the attack on the Chicago Police Department at the Democratic Convention of 1968. What was done to confirm the accuracy of these allegations against Gertz? The statement alleged against Gertz were false, as the respondent did not verify any of his accusations were with valid sources. Gertz did not have a criminal record, and although he had been a member of the National Lawyers Guild, it was 15 years earlier, and there was not any evidence to connect the organization to the 1968 Democratic Convention protests. Lastly, it was not concluded that Gertz had been a communist frontier Leninist or participant in the Marxist League for Industrial Democracy or the Intercollegiate Socialist Society. Furthermore, the managing editor of the American Opinion stated that he had orchestrated a detailed research of Nucio's case, of which he had not done thoroughly, before authorizing the photograph of the petitioner with an accusatory headline attached captioning, "Elmer Gertz of Red Guild harasses Nucio," was placed on newsstands in the U.S. and reprints on newsstands throughout Chicago. How do you think these allegations affected Gertz's reputation? According to the diversity action filed by Gertz, he stated that his reputation had been tarnished as an attorney and as a citizen. I believe this to be true because as an attorney, people trust him to uphold the law instead of violating it as the magazine alleged. His legal practice was placed under scrutiny because of the false allegations that also linked him to protests for communism during the Democratic Convention of 1968. Such acts can be quite damaging to a lawyer who interprets Constitution instead of trying to alter it as communism would meet the standards of their own undiversified agenda. As a citizen, Gertz suffered as well, especially in the country where the majority supports democracy. During a year when this case occurred, the United States was ending a feud with Russia and Cuba, two countries who support communism. Allegations of communism could have gotten Gertz into serious trouble with the U.S. Secret Service, Central Intelligence Agency, and the Federal Bureau of Investigations, as they could have accused him of espionage, terrorism, or treason against his own country. In addition, his family could have been endangered by those who opposed communism and wanted to act as vigilantes and patriots of their country. Consequently, I believe Gertz lost a tremendous amount of money while paying for legal fees without earning revenue through new client partnerships. These allegations were detrimental to the career and personal life of Gertz. What would you have done differently than Welch to avoid the lawsuit? Considering all of the actions committed by Welch in this civil action, I would not have done anything remotely close to what he did. In retrospect, it is always imperative to retract your actions after a tie-in situation such as this one caused by improper actions and falsifications. Welch created a news story using false headlines and information so that he could maintain relevancy and acclaim as a journalist. By alleging that Gertz was a communist, which also be considered on the same level as a terrorist, depending on the perspective, he was placed in harmful situations involuntarily. As journalists, we understand the hunger and excitement for a great news story that has everyone talking and desiring to know more about the writer and publisher. However, when investigating, it is imperative to validate all facts and reasonable and reliable proofs and sources to negate possibility of falsification leading to defamation. We cannot conveniently uphold the First and 14th Amendments as we are trying to prove our innocence against lies that we have caused by our own unlawful and immoral practices. Welch seemed to be greedy to disclaim the petitioner that in the end, he truly did the most disservice to himself professionally and personally. How can you relate what you have learned from the Sullivan and Gertz cases to your future work in communications industry? After reviewing the case study, I determined that Welch used total and proper judgment when creating this article about Gertz. As a journalist, I cannot imagine placing myself in a position to be chaotic in my thinking, whereas I would jeopardize my own career as well as the career while also intentionally harming the other person as well. Many journalists find themselves desiring fame and notoriety, so they commit actions that sabotage themselves more than anyone. Welch totally discredited himself as a journalist and harmed an innocent person with his unjustifiable actions. As a professional, I must uphold professional standards, of course, because I am entering the new field of public relations, I will be excited about great press releases and news stories and efforts of capitalizing off of them in my career advancement. However, I must use my morals and proper judgment when making such decisions as they can truly harm my career instead of advancing it. The New York Times presenting statements to the world as they depicted them on TV screens across America during the height of the civil rights movement. Although they should have validated their sources, they had more credibility than Welch's. These were major stories. They were covering most people not hearing the information, and most people were not hearing the information for the first time. I would have not implicated the police department as they did without factual evidence to defend my allegations. Nonetheless, their stories had more weight to them than those of Welch, which were fabricated lies. It is vitally important to maintain professionalism with both of these cases to avoid within both of these cases to avoid defamation and libel suits, regardless of favor or unfavorable outcomes. As a professional, they are not only costly to my business, but also it discredits my image and professionalism.